Thank you, Madam Chair. For the record, my name is Dan Gardner, Commissioner of the Bureau of Labor and Industries, and I couldn't agree more with our Secretary of State about the problems with signature gatherers. The Bureau of Labor and Industries has received over a dozen wage claims and complaints against political and initiative signature gathering businesses in the last 2 to 3 years. Workers have actually been paid from the Wage Security Fund when 2 of these businesses ceased operations and failed to pay final wages that were due their employees. The biggest recent case involved B&P Campaign Management Incorporated, the owner was Brian Kenneth Platt, who had contracted with Democracy Direct Incorporated to obtain signatures for several initiative petitions, including Initiative 14, which dealt with tax deductions, and 24, the judicial elections, dealing with the Russ Walker and Freedoms Works Group. Also, Initiative Petition 23, which dealt with insurance, which Mr. Sizemore and Oregon Taxpayers United was involved in. Also, they gathered signatures for Petition 57, the property condemnation, Ross Day and Oregonians in Actions. Allegations of being paid by signatures were referred to the Secretary of State's office. However, employees were promised pay rates of $12 to $15 an hour and then told they didn't collect enough signatures to earn these rates. Employees are paid in cash with no deductions made. Workers have very little, if any, training and seldom even know who they're working for other than perhaps the last name of an individual. These businesses are very difficult to serve. They have no real business location often and move around a lot. In one case, a woman reported to us that she was asked to meet one of the owners of the company in a hotel room, to which she told him she felt rather uncomfortable with that one. I mean, they have failure to pay minimum wage for all the hours work. The employers failed to pay final wages to several employees, requiring BOLI to pay wages to the workers from the Wage Security Fund. They failed to maintain time and payroll records as required. BOLI subpoenaed B&P business records in January of 2006, but because the law does not currently allow BOLI to enforce its subpoenas directly in court, we had to file a lawsuit, go to court 3 separate times in March, April, and May to compel production, which delayed our ability to determine who had been employed and whether wages were due. We are currently pursuing legislation this session that would allow us to have our investigative subpoenas more directly enforced by the Circuit Court upon a petition or motion to the court. The records that were finally produced by B&P on May 30th, 2006 did not provide information regarding the dates, hours worked by employees, and we assessed a $3,480 in civil penalties in these violations. Employers, as I've said before, are difficult to serve, rarely have a business location, but they appear to set up a really elaborate scheme of paying per signature and trying to hide it. At one point, Mr. Brian Platt was arrested, and Marion County Circuit Court found B&P management in contempt for failure to comply with the subpoenas served by the Secretary of State. BOLI sought and won an injunction in court to prohibit both Platt and B&P campaign consultants from employing persons at less than the minimum wage rate. Ultimately, we obtained a judgment against B&P in excess of $22,000 for the amounts paid by the Wage Security Fund, penalty wages, civil penalties, interest, attorney's fees, and court costs. These judgments have been referred to the Department of Revenue for collection, but because they are against a corporation only, and the corporation is no longer in business, it's unlikely any of these amounts will ever be recovered. You know, looking at the situation, if you're looking for potential solutions, there are 3 ideas that occurred to me personally. One, of course, is to give us more direct subpoena authority like the Department of Revenue and other departments of the state government have, where we can move quicker on these situations and not have to constantly go back to court. The second that I might suggest to you is, in addition to overseeing wages that are paid to an employee in minimum wage law, we also oversee the prevailing wage law. In a prevailing wage situation where you have a local municipality, and if you can extend that to the chief petitioner, they also have subcontractors, a general contractor that runs the job. They have subcontractors under them. Even sometimes the subcontractor has a subcontractor. In law, with prevailing wage law, all are joint and severably liable all the way up and down the chain. If one goes out of business, we go after the next, and the next, and the next, until we can get those wages that are due the worker on the job. If you look at it as that corollary, making them joint and severably liable all the way up to the chief petitioners, and I say that from a unique perspective. I have been a chief petitioner in 2002 of the minimum wage initiative. But I knew who the petitioners were that were out there gathering signatures for it. I knew how they were paid, and they were paid appropriately, and there were records kept. So anybody who says it can't be done, I'd say they're absolutely, completely, and utterly wrong. We did do it. I've been part of it. And I have no problem as a former chief petitioner being joint and severally liable and trying to show that we can accomplish this. One other, if I use the corollary to the prevailing wage law, general contractors are bonded. And last session, under Senate Bill 477, you might recall that subcontractors for performance and payment of prevailing wage law required a $30,000 bond on them. Now, I'm not sure, I'm no expert in the bonding market, but I know those bonds cost a contractor anywhere from $2,000 to about $5,000 a year to have them. If they had a bond in order to pay for those wages that are due and owed to workers, it would be another level of protection for workers that go out and go to work for those petition gatherers. With that, I certainly welcome any questions.
Thanks for your comments, and thanks for being here, both of you. Are there questions from committee?